Mr. Hardman from the prosecutor's office, Officer Henry and Kelly from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Yes, This already, 201 days of jail time credit, no restitution. All right, Mr. Hardman, anything on behalf of the victim?
Yes, Your Honor. Miss Garrity is present, and I think she wishes to address the court.
Okay. Hello, Miss Garrity.
Hi.
Tell me about this.
Okay, I know, okay?
That is really tiny writing. I'm impressed.
Got my glasses. Okay, though the experience was frightening in the moment at that time, it does not remain in my thoughts daily. I do not feel scared for myself when thinking of him, rather scared for others that may have the same experience or worse if he were to do something like this again. For that reason, I encourage incarceration.
Thank you, ma'am.
Thank you, sir.
Mr. Hardman?
Thank you, Your Honor. As the court is aware, this day back in August, the facts show that this defendant planned, stalked, looking for a victim that day to engage in the behaviors that he now has been admitted to, and the court will be finding him guilty of. What he found was 79-year-old Julia Garrity, who was simply going about her life, living a very independent life at that time, living on her own, in her own residence. She enjoyed living that life. That life has been changed. And a large reason for that was because of the behaviors that this defendant engaged in on that day back in August, as he stalked her from a Walmart parking lot, following her back to her residence, entering into her garage under a stealthy cloak of darkness with a mask and gloves, pinned her up against her car, and then began sexually touching her. She made the right decision at that point in time, which was to scream for help, which caused this defendant to back off, run to his car, and take off. Fortunately, due to technology, due to good detective work, the defendant was quickly found and apprehended. What was interesting about is where he was apprehended. We learned very quickly the defendant was employed at Mason Christian Village, obviously a residence filled with individuals of the same demographic as Miss Garrity, which obviously questions what his motive, what his reasoning was, and knowing that this activity that day was planned, very concerning, particularly on his part. The activities this man engaged in are above and beyond anything that we normally deal with. This is a case that is out of the ordinary. It certainly shows a great deal of planning and to engage in changing and radically affecting the life of a 79-year-old woman. As a result, we ask that this court impose a sentence of at a minimum of 8 years. It's an appropriate sentence for the two F1s. The defendant now has admitted to committing the kidnapping and aggravated burglary. I think it's appropriate under sentencing factors, the seriousness of this defendant's conduct, and to certainly send the message not to demean the seriousness of the behavior that this defendant engaged in back in August. We would submit, Your Honor, that the GSI and the kidnapping merge, so counts 2 and 3 merge. We are obviously asking to proceed forward on the kidnapping and the aggravated burglaries counts 1 and 2 pursuant to that. Thank you.
Officer Henry, what's your take on this?
Your Honor, from what we discussed in chambers, I do believe that there would be nothing further for me to explain to the court other than proceeding forward at this time with the prison sentence and being considered not amenable to community control at this time. It would be our recommendation from probation.
Mr. Kirby?
Thank you, Judge. You are not going to hear an excuse from me or my client as to what transpired last year. Given the facts of this case, given the facts of Zach's history, the fact that he's a 30-year-old who's married, he's employed, he's a father, I think we are left with the inescapable conclusion that there is something mentally wrong. At least at the time of this offense there was. And in which case he is in dire help of need. In talking with Zach, his wife, his mom, I don't think he's an evil person. He knew what he did was wrong. He knows what he did was wrong. He was adamant to me since I began representing him that he did not want to put the victim through a trial. He's exhibited remorse in what he did. He's unable to explain why he did it. I think what is also telling is when he was apprehended by the sheriff's office just a day or two after this offense, is he gave the sheriff's office a very candid confession for what he did. He was remorseful when he told them what happened. And to me, I think that is a cry for help of somebody who understands that they need the help. I filed a sentencing memorandum with the court that details some of Zach's history as a letter from his mother. I also spoke with Zach's wife, who is imminently contemplating a divorce action against him, but she still says that he's a good father, and she says that treatment would be appropriate for him in light of this offense. So based on the foregoing, Judge, and based upon what's set forth in my sentencing memorandum, we would ask for a sentence that does promote his effective rehabilitation and credits him the 201 days that he's already served. That's all, Judge.
Mr. Dickinson, you get the last word in all this. What do you want to tell me?
Your Honor, I'm not a terrible violent criminal. I made a terrible choice that day and harmed a completely innocent woman. I want her to know that I am sorry for what I did, and I'm thankful that she's not living in fear like she said. That's really all I wanted for her. That's all.
So here's the thing, Mr. Dickinson. I've been a judge for 20 years now, and very seldom does a case come in front of me that makes no sense to me. Most cases make a little bit of sense, where we have somebody who has a history as a sex offender and doesn't have a particular amount of empathy for their victims. They pick out a victim that is somewhat susceptible, maybe somebody that's not going to put up a fight, or somebody that's not, that creates a situation where you're going to get away with this. It doesn't fit that box. Your only criminal history is that you have a marijuana conviction from out of state and a couple of dismissed charges. And the prosecutor's recitation of this, which is unexpected to me, is what I expected, which is I have a victim that is very impacted by this and very scarred by this. I hear from Ms. Garrity, and the fact that she is tough and fears for the safety of others, also very unusual in a case like this. So it's very difficult to put this case into any particular box. But as I'm up here, Mr. Dickinson, I do three things. I punish people, I protect the public, and I try to rehabilitate offenders. Those are the three things that I do. And the number one thing that I do, Mr. Dickinson, is I protect my community. And that has to be done. I have always been of the position that you cannot go into somebody's house, even a garage that's part of the house. You just can't. Our house, our castle as it's called sometimes in the law, that is the place that we go to get away from everything else that occurs in the world. And the fact that this took place in the victim's home, very significant to me. And I do think that, we all sort of shake our heads and be like, oh, there must be some mental health component to it, although your history doesn't really suggest that. Your history doesn't suggest that this is a particularly harsh punishment case. I do think that supervision is essential to this case. Bottom line, Mr. Dickinson, you are among those people who need to be separated from the rest of us so that we can be protected and that we can feel protected. Both of those things have to happen at once. I am going to sentence you to 8 years in prison. That is going to be 8 to 12 years in prison. Again, we have the Reagan-Tokes sentence, which is an indefinite sentence. Here is my hope, though, Mr. Dickinson, and I like to be upfront with my sentencing because I think it's fair to you. I think it's fair to the victims in the case. You become eligible for what we call judicial release after 5 years. And it is my hope, Mr. Dickinson, that you behave yourself while you are in the institution so that this becomes a 5-year sentence instead of an 8-year sentence, because I want to be able to supervise you and to engage you in some sort of treatment. So at the end of your sentence, they just don't open the door to the prison and shove you out. But if you don't behave yourself while you are in the institution, you do things that suggest to me while you are in there that you are more of a threat than I believe you to be, then the 8-year sentence probably seems more appropriate. If you commit new crimes while you're in the prison, then the Department of Rehabilitation Corrections, they make the decision whether to keep you up to the 12 years. This also includes a mandatory period of post-release control. The adult parole authority is going to supervise you for 5 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for that new felony. I'm going to give you credit for the 201 days that you have already done. I find that you are indigent for the purposes of fines and costs. There will be no financial sanction. This is going to be an 8-year sentence on each of these charges to be served concurrently, which means at the same time as one another. You are going to register as a Tier 2 sex offender, and you're going to be enrolled in the Violent Offender Database. Is there anything else we need to do or anything that I forgot?
No, not from the state, Your Honor.
I don't believe so, Judge.
Finally, Mr. Dickinson, you have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or pay the costs, they will all be provided to you at no charge. I am going to remand you to the custody of the county sheriff for transport to the institution. Everybody who is on this side of the courtroom, just have a seat for just a second because Mr. Dickinson is on his way out. Then everybody can clear out. Deputy, you can go ahead and take Mr. Dickinson out. Thank you. What are the facts?
Your Honor, on August 21st of 2025, shortly after 4 o'clock in the afternoon in Deerfield Township, Warren County, Ohio, our victim, Julia Garrity, 79-year-old resident of Deerfield Township, was running errands at a Walmart where the defendant then followed her out of that Walmart and back to her residence in Deerfield Township, at which point in time the defendant, wearing a black mask, gloves, black hooded sweatshirt, and black sweatpants and black shoes, stealthily and forcefully entered into the attached garage of Miss Garrity's residence and proceeded to confront Miss Garrity. The defendant at that point in time took his body, pressed it up against Miss Garrity, therefore restricting her of her ability to leave, threatening physical harm to her in the process, and then proceeded to use his hands to touch Miss Garrity across her breast, waist, and hips for the purposes of sexual gratification of himself. Miss Garrity at that point in time fled or screamed, resulting in the defendant fleeing from the scene. Police video surveillance, both at the Walmart, from neighborhood ring cameras, were able to ultimately track information about the vehicle the defendant was in that day, and that's what led to his apprehension. Ultimately, upon his apprehension, he did speak to police where he did admit to being the individual who attacked Miss Garrity that day, and that his purpose for doing so was based on sexual motivation.
Anything on those facts, Mr. Kirby?
No, Your Honor.
Mr. Dickinson, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the right you're giving up by entering a plea?
Yes, sir.
Which plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty.